Hello viewers, welcome to our program on immigration and legal affairs. I am your immigration attorney Michael Fulwani, and once again we have with us David Nachman, my partner, my attorney for the immigration service, and all of yours too.
Thank you, Michael. Nice to be here again.
David, something that you will love to hear this. This is a letter from one of our viewers with a nice comment. So let me read his comment first, then the question. He says that your program on immigration on TV Asia is extremely helpful. We thank you for providing such valuable information. Please continue to do so. We certainly will. And thank you very much for these comments and compliments. And I hope that most of our other viewers feel the same way.
Absolutely. It's so nice to hear our viewers find that our information is helpful to them.
Okay, here's the question. We're getting a lot of interesting questions, by the way. He says that you said on one of our programs that if a person who is an unlawful status in the US and cannot adjust status as a permanent resident and will be subject to 10-year bar if he goes back to India to apply for an immigrant visa at the American consulate, under the new policy, this is the new policy I think we had mentioned that he is talking about. Right. He says under the new policy that person can apply for a waiver of unlawful presence in the US, and if he gets the waiver approved, he can travel to India and apply for an immigrant visa without a problem. The petition for my friend was at the time he filed was a US citizen, and it was filed in October 2000. Can he take the advantage of the new policy, get the waiver, go back to India, get a green card without any problem? Let me give a brief answer and you make more comments on
okay, sure. Comments. Absolutely.
I think first of all this is available only in immediate family relative category, not all the categories, so that's an important. This is also not in effect at this time, but may likely to happen soon.
Right. That's very important to point out to our
viewers. And unfortunately, I would say the reason he is asking the question because it appears that he is not eligible for 245I. Because some people, even if he came without crossing the border, overstay and all that, if he is eligible under section 245, he shouldn't go to India even with advance parole. He should really adjust the status in the US.
Sure.
So you give some comments and then I have one last word to say on this question.
No problem, Michael. Actually, a couple of things. Number one is that what we're talking about here is a new rule. It's actually out for rulemaking at this very time as we speak. And it's our hope that many people are issuing their comments to the CIS with regard to this rule that was published in the federal regulations. And it has to do with what's called a provisional waiver. The provisional waiver is an application which is made in the United States before the individual leaves and goes back to the consulate. And the way something like this plays out is that because the individual is married to a US citizen, they file a petition for an alien relative. It's done on an I-130 form. Then of course when that form is approved, when that case is approved, the case then gets sent to the National Visa Center, and then the National Visa Center sends it to the US consulate in India. And currently the individual then goes to India to process their green card through what's called the consular processing procedure. That case of course ends up getting denied because the individual's accrued unlawful presence, in this case has become subject to the 10-year bar under 212A9 sub 2. And what ends up happening is that the individual's case is denied, but they have the right to apply for a waiver of that 212 inadmissibility provision of the law. And they do that by showing extreme and unusual hardship to a US citizen, a child, and or a parent. And then they have the opportunity to get a waiver. And so that's the way it plays out. Now what the new regulation is doing is giving them the opportunity to apply for this provisional waiver in advance of leaving the United States. And the benefit, of course, is that you'll know before you leave whether or not, hopefully, that case will be approved. What I think our viewers should know, which is very, very important, is that this is a new change as to all the other consulates in the world. Currently, this is what's going on not exactly what's going on, but something very similar to what's going on in Ciudad Juarez. Ciudad Juarez, the U.S. consulate in Mexico, has a provision or a special procedure, let me say, where they are entertaining these types of cases. It's not exactly the same. It's not like a provisional waiver, but it's done on a basis whereby the individual hopefully won't have to spend extensive periods of time outside the United States. We've actually been effective in getting people these waivers and getting them back into the United States in a matter of weeks. So I think what it is that for lack of a better way to describe it, they were using the Ciudad Juarez program as sort of a pilot program before they rolled it out to the rest of the consulates in the world.
Very quickly, let me say, if a person who is married to a citizen, he wants to apply, he cannot adjust because he doesn't qualify for 245I. Somebody told him, you go and you can apply at the American Consul India, takes a flight, goes for the interview. American Consul says everything is fine, sorry, but I cannot give you a visa because you are under a 10-year bar. But you can apply for a waiver. So he said, okay, I'll apply for a waiver, no problem. He files an application for waiver. Application is forwarded to the Immigration Service in New Delhi, which is the overseas immigration office. It takes several months. So this person is now waiting in India, 6 months, 7 months. Finally, if it is denied, he's stuck for 10 years.
That's correct.
Because this is only available on unlawful presence, not on fraud, not on the charge.
And that's really important to point out, because in the event that there is some other basis for inadmissibility, then the individual is going to have to wait.
That's
so
correct.
It has to be really clear.
No, that goes even with the new policy. I'm talking about under the old, he had to wait and then take a big risk, a big chance.
Exactly.
Now this viewer of ours kindly, I think, looks like he presumes that once I get the waiver from the US, because I don't need to get a waiver there, I'm getting an advance waiver here. Then I go there, go to the consul, he denies the visa, 10-year bar, I say, here it is, my waiver, now give me the visa. It's not that simple, because the consul will have an extensive interview. If you entered without a visa from the border, consul is going to, how did you travel to US, what the agent, the money, this and that, and a lot of other questions come in. So it could be, even with that, it's dangerous. The bottom line is, in a very good clean-cut case where a good immigration lawyer tells you there's no other issue at all in your case. If he came just with a visa and everything was fine and he just overstayed, for H1 he came in, F1 he came in, he overstayed, but he can maybe able to adjust. But I'm saying, in a situations where he cannot adjust for whatever reason, then it's okay to take that chance of a waiver, and because we don't see a hole that would require a fraud charge or a misrepresentation charge or anything of that sort.
Right. So Michael, before we go to the next question, I think it's important for us to make two important announcements to our viewers. One is that we have a GOPIO panel program that's coming up, and also that we have a global entry program that's coming up. The GOPIO program is a panel discussion of the immigration lawyers from the NPZ Law Group, including one Canadian lawyer. Will be discussing immigration issues, and that's being held. Where is that being held, Michael?
It's in Guru Palace in North Brunswick.
Okay, great. And that's on
June 24th, Sunday, 12:30 to maybe 3:30. So we are going to be there at least for about 2.5 to 3 hours. We will give a presentation on all important developments. We'll advise you of what happened in our recent trip to India, our meetings with the American consular officers, how the American consul are processing cases, why they deny sometimes, and what kind of problems of processes that are now currently there.
So there'll be 4 lawyers from the NPZ Law Group. It'll be Michael, of course. It'll be myself. It'll be Madhvi Samudrala. And it'll also be Veronique Malka, who is a Canadian lawyer, and she'll be there to answer any questions that you might have about possibly immigrating to Canada. That's been a very
nice
popular issue.
Luncheon seminar, and the full Indian lunch will be there. And I think there's a very reasonable cost of $20 or $25. And you will love to be at that afternoon, meet all of us, give us an opportunity to meet you. We can exchange our views, we can answer your questions, and hopefully you will come there. Please make sure the seats may be limited. that we recommend that you try to get your reservation or admission done as soon as possible.
And of course, there's no need to say how important the GOPIO professional organization is for those of you who are familiar with the initiatives of that organization. Michael, I think this is a good time for us to take a break, and then when we come back, we can talk a little bit about the Global Entry Program, and we can talk a little bit about how TV Asia was instrumental in helping us get CBP to do some enrollments for the Global Entry Program.
So stay tuned, we will be back. Welcome back.
Well, I think you have another question from one of our viewers. We'd like to go to some of your questions, things that you have on your mind, and try to answer them for you. So,
yeah, we started answering questions in the last program. We have many more. But let us, every program we do, next 1 or 2 programs, we try to respond to some of your questions. And thank God we are getting very interesting questions, David. Here's another one, more like cup of tea, your cup of tea. He says, I'm on a student visa. He says, my employer recently filed an H-1B petition on my behalf under premium processing, and I was expecting to get the approval within 2 weeks. Now, instead of getting the approval, my employer says that he has received an RFE and he has to reply to the same and submit several documents. I'm really worried a lot, and I don't understand what is this RFE and whether my H-1B petitions will be denied. Kindly help me. Yes, we will help you and trying to answer the question as we can, but sometimes it's not just easy to just answer a question like on a television program. I'm saying David will give you some general information about what RFE is, why the RFE is issued, and what the employer does when the RFE is received, and then what happens if the immigration service is satisfied, petition gets approved or sometimes denied, and the implications.
Okay.
So your turn now.
Okay, so before I discuss the RFE, you indicated that this was my cup of tea, but I think masala chai is my cup of tea. But before we get to, so RFEs, let's talk a little bit about RFEs. First of all, RFEs are dreaded by, well, it's dreaded by our office. We don't like to get RFEs. We actually do everything that we possibly can to avoid what's called the RFE, request for evidence. When the government submits a request for evidence, which by the way they can do in any case, they have sole discretion on whether or not they want to issue the RFE. And what is the RFE? Well, the RFE can be anything from 1 sentence long to 4 pages long. Oftentimes what ends up happening is if an RFE comes, it asks for information that has been previously submitted. And that's very frustrating to us because it's almost like, to us, it's a slap in the face because the government is saying, I didn't even read what you submitted. And that's very frustrating for me. But we also understand that the government works in certain ways. It has its own set of rules. And RFEs have been issued actually in what are called template formats. And so we're able to see in advance what the government is possibly going to be issuing to us depending upon what the case is. For example, in this case it was an H-1B. So we are not as familiar with the H-1B's RFEs as templates, although lots of experience has shown us what those questions might be. However, in the L context, those are published, and so we can see what an L1B RFE is going to look like, so we can almost get our responses ready in advance. Now, with regard to this particular question, when we get an RFE, oftentimes it has to do with several things. Number one, an RFE on an H-1B might be something along these lines. Prove that the business requires a professional who is serving in a specialty occupation. So it would be our responsibility then to go back, even though we've proved it already in the initial case that we submitted, to show why the individual who's taking up this position has to be an individual who has the equivalence of a US baccalaureate degree or its equivalent in the United States. So that's what an RFE is. what is an employer to do? Well, the best thing that an employer could do is reach out for an attorney who has some experience in dealing with an RFE. If you're doing them in-house, it's highly recommended that you take a look at all your RFEs and try to get a sense of where the government might be going with them. Interestingly, there are certain questions that are behind the questions when the government asks. So oftentimes what they're trying to do is figure out whether or not the individuals who are in H-1B status are being paid the federally mandated prevailing wage, which is designated on the labor condition application, which is the underlying document for the H-1B. Oftentimes they might be looking at something else, even though they're not necessarily required, you as an H-1B employer, to go out and recruit an individual, a U.S. worker, for the job. Oftentimes in the RFE, they will actually ask you what type of recruitment efforts you have made. So what should an employer do? Best thing in the world when you get an RFE is to seek out good, competent legal assistance to make sure that not just that you're answering the RFE, because yes, it's true, there is something that you say back, but there also might be a hidden message in the RFE. So you want to make sure that you respond appropriately.
But this RFE is not addressed towards our viewer. They are not asking our viewer, although indirectly sometimes the questions raised in RFE may relate to the H1 beneficiaries' education experience or something like that. But most of the time we see the RFE is related to the questions from the employer.
Correct.
And it is the employer that was to put together all the documentation information and submit. As you said, the good advice is always, it's a good idea to have a very experienced lawyer who you know that can do the job right. And this is the Madras Coffee question. Now here's the question, very interesting, and why I'm saying very interesting, but this is something I've been doing for the last maybe 30, 40 years. So I can tell you complete information and very valuable, important information. It's like this. I have recently opened a company which will be bringing some dance and drama groups to the US for concerts, mainly from Gujarat. I finalized agreement with a new group. They have advised me that the American consul will issue visas only after a petition is approved by the Immigration Service. He wants to say, I want to know how the petition is to be filed. He has never done this before, the first time he's doing it.
Okay.
What documents have to be submitted? How long would it take? Will the Immigration Service approve the petition? After approval, would there be a problem when they go to the American consul for getting a visa stamp? It's a lot of
questions. Just one question.
One question.
One more question.
It's a lot of smaller groups.
Just one more question.
So first of all, let us welcome to the club of entertainer companies. And I was telling you about my background on this. I think it should be about 40 years ago almost, when I got the first, I think, artist from Pakistan was Ghulam Ali, and then Mehdi Hassan, and then many, many more. I can go probably maybe 1 hour of just giving you all the names of singers, dancers, artists, Asha Bhosle ji. I mean, and then that was at that time it was H1 visa at that time. Later on the law changed and that became a P3 visa, the cultural unit groups.
Well, that's important for our viewers to understand, is that H-1Bs really were that was the visa of choice back until 1991, when the law changed. And what they did is they put a cap of 65,000 in 1991, and then they broke it out into O's, P's, Q's, R's, and took all of those out to make everyone happy, because they put the cap in.
So the P3 visa is the right visa for performers, people that come for dance groups, for dramas.
Well, what about O? I was thinking O possibly
then
too.
As I said, after a few years, it's about maybe